government. So it is also having appellate jurisdiction, which means the Supreme Court is an highest appeal court in India. So the Supreme Court will hear appeals from the people who disagree with the decisions of the lower court, like high courts or other courts. In three different categories of situations, an appeal may be taken by the Supreme Court. If we see, one is constitutional interpretation related cases, and another one is civil cases without regard to any constitutional issues, and the third one is criminal cases are heard regardless of any constitutional issues. So these three types of appeals may clear by the
Sir, voice is not clear, sir. We can't able to hear you clearly.
Okay. So sometimes appeals may be taken by the special leave. In some cases where a matter of justice is at stake, the Supreme Court may intervene in the decision of the High Court and other tribunals. So according to Article 136, the Supreme Court is granted this residual authority. So, and also the Supreme Court is having advisory jurisdiction, which means in case of President is having some doubts regarding the constitutional rules, the President may occasionally ask the Supreme Court for its opinion on the problem. So at that time, President may believe that the issue raises crucial issues or matters of public importance, in which case it would be appropriate to ask the Supreme Court for its view, according to Article 143. So please show that mute your So Article 32 says regarding writ authority of the Supreme Court of India. As we discussed in the concept of fundamental rights, Article 32 says five various types of writs are there to protect the fundamental rights. So a person may request to Supreme Court to issue writs in the event that their fundamental rights have been violated. So, however, this only applies if a person's fundamental rights are violated. As we discussed in previous class, those who are violating are those who is neglecting in the implementation of these fundamental rights. The persons or the institutions may approach higher courts like High Court and Supreme Court. We can approach them and they may issue five types of writs over the issue like habeas corpus, mandamus, prohibition, certiorari, quo warranto. These five types of writs are there to protect our fundamental rights. So this is the writ jurisdiction of the Supreme Court. So the Supreme Court always records its proceedings which take the shape of a case law. So all Indian courts, including lower courts like High Court and subordinate courts like district courts or any other court, are required to abide by the such judgments. So the Supreme Court judgments are the proceedings are the important what we say guidelines to the lower courts. So if we see these guidelines should follow by the all of the lower courts in the India. So if you see, as we discussed in original jurisdiction, some matters does not extend this jurisdiction of the Supreme Court, like any dispute arising out of any pre-constitution treaty or agreement or other similar instrument will not include this original jurisdiction of the Supreme Court. So only the disputes between the center and the state governments are centered to any states, or one or more states, or disputes between the two or more states. Like if you see disputes like water disputes will be there, boundary disputes will be there, or river water sharing disputes will be there. So at that time, the Supreme Court may uh, uh, conclude their uh, dispute. So if you see uh, the court of record, which means the Supreme Court's judgments, proceedings, and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. So they are recognized as legal precedents and legal references. So it has power to punish for contempt of court. So either with a simple imprisonment for term up to 6 months, or with fine up to 2,000, or with both. So, and also one of the important authority of the Supreme Court, if we see about that, the concept of judicial review, according to Article 13 of the Constitution of India, it says about the judicial review power of the Supreme Court. So judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of the both the central and state governments. As we discussed in previous classes, if parliament or legislative assembly pass a bill, so the judicial authorities are the legal advisors of the governments will examine those acts or proceedings passed by the parliament. So they will examine that whether it is following constitutional provisions or not, whether it is according to the constitution or not. So they will clarify that issue. So if they are against to the constitutional rules, so they may suggest to the government to change or modify the provisions which are placed in that act. So after that examination of by the constitutional advisors like Attorney General to the Union Government, Advocate General to the state government, then only the acts and enactments will introduced in the houses. So on the examinations, if they are found to be violation of constitution, they can be declared as illegal or unconstitutional or invalid by the Supreme Court. Consequently, they cannot be enforced by the government. So if we see recent issues in Supreme Court, master of roster, it refers to the privilege of the Chief Justice to constitute benches to hear cases. So the controversy has emerged in the Supreme Court over absolute power of Chief Justice and the judicial administration. So the independence of judiciary is one of the important authority to review these type of legislative enactments by the union and the state governments. So if we see, the constitution has many provisions to ensure the judiciary's independence. So like security of tenure, the judges of the Supreme Court are given security of tenure. Once appointed as judge, they will retain their age at the age of 65 years. So they can be removed only by the President of India, as we discussed in the President's executive powers. They can be removed only by the President of India on the grounds of proven misbehavior or incapacity. So this requires a special majority according to Article 368. So 368 says about constitutional amendment system. So we are having three types of constitutional amendments are there. One is with a simple majority, another one is special majority, and third one is special majority with some states' acceptance. So, and also salaries and allowances of the judges can be decided by the parliament. So the expenses of high court are charged on the consolidated fund of the state, and the Supreme Court judges' salaries and allowances will be drawn by the consolidated fund of India. So the Supreme Court's power and jurisdiction can only be added by the Parliament and not be curtailed. So the conduct of any judge of the Supreme Court in the discharge of his duties cannot be discussed in the legislature. So the Supreme Court has the power to punish any person for its contempt as per Article 129. So the separation of the judiciary from the executive has been mentioned in the directive principles of the state policy, states that the state shall take steps to separate the judiciary from the executive in the public services of the state. So according to Article 50, there shall be a separate judicial service free from executive control. So as we discussed, so the independence of judiciary has been given by the our Constitution of India. So if we see, if we discuss about the meaning of the independent judiciary, means other branches of the government, namely executive and legislature, does not interfere with the judiciary's functioning. So that's what we call it as independent judiciary. So no government officials interpret into the exercising powers of the judicial system. So the judiciary's decision is respected and not interfered with any other organs like executive and legislature. So it also means that judges can perform their duties without fear and or favor. So independence of judiciary also does not mean that the judiciary functions arbitrarily and without any accountability. So it is only accountable to the constitution of the country. So that's what we call it as the independent judiciary. So the constitutions of India provides a number of provisions that ensure that the independence of judiciary is maintained and protected by the constitution. So if you see the functions of the judiciary, certain administration of justice. So the primary and chief function of the judiciary is to apply the law to specific cases in settling disputes. So as we discussed in original jurisdiction of the Supreme Court, so Supreme Court has the highest authority to control the union and state governments in case of they are facing some disputes and conflicts between the state affairs. So at that time, the Supreme Court can take that conflict zone and resolve by the judgmental orders. So if someone is found guilty of violating the law in the course of the trial, the court will impose a penalty on the guilty person too. So, and also Supreme Court acts as a guardian of the Constitution. As we discussed, the Constitution is implemented by the and protected by the Constitution, Supreme Court of India. So the highest court of India is Supreme Court. So acts as the guardian of the Constitution. So the conflicts of jurisdiction between the central government and the state governments are between the legislature and executive are decided by the court only. So any law or executive order which violates any provision of the Constitution is declared unconstitutional or void by the judiciary. So this is called judicial review. So as we discussed, Article 13 says regarding this judicial review, has the merit of guaranteeing and the fundamental rights of individuals and ensuring a balance between union and the units in a federal state. Units means we hear states like Telangana, Andhra Pradesh. So, and also Supreme Court acts as protector of fundamental rights. As we discussed, Article 32 says the protection of fundamental rights will be implemented by the highest courts like Supreme Court, and also High Court also has having the to issue these writs according to Article 228. So, and also the higher courts also perform the function of supervising the subordinate courts in India. So High Courts and Supreme Courts also acts as superior courts and also having supervisory functions. So, and also Supreme Courts and the entire judiciary system playing a special role in a federal state like India. In a federal system like India, the judiciary also performs the important task of settling disputes between the center and the states. It also acts as an arbiter of disputes between the states. As we discussed, most of the conflicts are raised by the states in the name of river water sharing or funds sharing, funds allocating by the union government, and also some other cases. So at that time, the Supreme Court will play an important role to resolve the issue. So, and also Supreme Court conducting judicial inquiries. So judges normally are called to head commissions that inquire into cases of errors or omissions on the part of public servants. So at that time, the government can create a special committee to review the fact what's going on there. So the committee will be established for the fact-finding basis. So at that time, Supreme Court can decide to nominate a judge from the Supreme Court. So to review the dispute. So, and also you can see some miscellaneous functions also there for the Supreme Court, like transfer of cases, appeals from one high court to another high court. So the authority is given to the Supreme Court to transfer the cases from the one high court to another high court. So, and also withdrawal of cases from the high court, and also precedent, which means law declared by the Supreme Court binding on all courts according to Article 141, and also doing complete justice by the Supreme Court, and also Supreme Court is having rule making power, and also it may interpreter of the constitution, because if someone violates like state government or union government, then the Supreme Court will enter into the issue to protect the constitution. And also the highest authority, that is the supreme authority, which is judicial review. So if judicial review not given to the Supreme Court, the governments may misuse their power to create any law for their benefit. So they may make any constitutional changes also if Supreme Court is not there. So that's what Supreme Court is acting as protector of the Constitution of India. So as we discussed, that's what the Supreme Court is highest judicial court and final court for the appeal in under the Constitution of India. So India is a federal state because we are having both governments. At the union level, we are having union government. At the state level, we are having state governments. And later, we are having local governments. But in a federal structure, we are distributing powers between the union and states according to the Constitution of India. So that's what the name has given to the India. So if we see the judicial review and judicial review of the Supreme Court of India, India has having independent judiciary with executive jurisdiction over the acts of legislature and executive. So these judicial review can be defined as a doctrine under which legislative and executive actions are subject to review by the judiciary. As we discussed, that's what the union government is appointing a legal advisor to the union government in the name of Attorney General. State governments are also appointing legal advisor to the state government in the name of Advocate General. So it is generally considered as the basic structure of independent judiciary. So, however, the judicial review can classified into three categories, like reviews of legislative action, review of executive judicial decisions, and review of administrative action. So, and also as courts have wide powers of judicial review, these powers have to be exercised with great caution and control. The limitations of these powers are it is only permissible to the extent of finding whether the procedure in reaching the decision has been correctly followed, but not the decision itself. So it is delegated to our superior courts only, that is Supreme Court and High Court cannot interfere in policy matters and political questions unless absolutely necessary. So law once passed may become unconstitutional with passage of the same. With changed situation, this may create vacuum in legal system. So it can be said that directions given by the court would be binding only till legislation is enacted. That is, it is temporary in nature, can interpret and invalidate a law, but it cannot itself make laws. However, most of the times there are also cases in India when executive has ordered judiciary to review policies. For example, in Ministry of Health versus Treatment Action Campaign, the government itself gave direction to review its policy regarding distribution of antiretroviral drugs and plan an effective and comprehensive national program to prevent mother-to-child transmission of HIV. So it is one of the examples. If you see the concept of judicial activism, it can be defined as a philosophy of judicial decision making whereby judges allow their personal views regarding a public policy instead of constitutionalism. So some cases of activism in India are Golaknath case, in which Supreme Court declared that fundamental rights enshrined in Part 3 are immutable and cannot be amendable. Later, Keshwanand Bharati, whereby Supreme Court introduced doctrine of basic structure, that is, Parliament has the power to amend the constitution without altering basic structure of constitution, as we discussed in first class about basic structure principle. So Supreme Court assumed a supervisory role in CBI investigation of 2G spectrum scam, invoking terror laws against Hassan Ali Khan are the one of the examples for this judicial activism. Moreover, the judicial activism also faces certain criticisms. It is often said that in the name of activism, judiciary often rewrites with personal opinions. Secondly, the theory of separation of powers is overthrown or dissolved or displaced. However, its importance lies with position accorded to Constitution of India as a place of hope for aggregated persons. So there is only a thin line of separation between review and activism. While judiciary review means to decide if the law or act is consistent with the constitution, On the other hand, judicial activism is more of a behavioral concept of a judge concerned. So it is a majorly based on the public interest, speedy disposal of cases, etc. With the power of judicial review, the courts acts as a custodian of the fundamental rights, as we discussed in Right to Constitutional Remedies. Article 32 says that the Supreme Courts and High Courts acts as a custodian of the fundamental rights. So the power of judicial review is recognized as the part of the basic constitution of India. So the activist role of the judiciary is implicit in the said power. So with the growing functions of the modern state, judicial intervention in the process of making administrative decisions and executing them also has increased. In addition, judicial activism, keeping in view the ideals of democracy, is in fact necessary to ensure that unheard voices are not buried by more influential and vocal voices. So, if you see many cases, many examples are there, judicial activism and judicial review regarding. So, the interpretational and observer role of the judiciary over the legislature is called judicial review. The judiciary is the final authority for the interpretation of Constitution of the India, and the judiciary can prevent it by declaring the act or action ultra virus, like if the legislature transgresses the power given to it by the Constitution. So this power is called as judicial review. While judicial activism is the concept how actively and quickly the judiciary performs the act of judicial review. So the readiness that the courts have achieved in exercising power to uphold the values of the Constitution have been generally come to the extent that judicial review has gradually acquired by the form of judicial activism in India. So, judicial activism is the extent and the vigor and the readiness which courts exercise their judicial power. So, there is a marked difference between both of them. So, courts has actively performed an interventionist role, and that we have witnessed the phenomenon of judicial activism. So the courts have overthrown or at least liberalized the concept of locust stand to allow any public spirited person or organization to bring to the notice of the court any matter of injustice and violation of constitutional rights of any downtrodden and unprivileged classes of society. So the court has expanded the scope and amplitude of Article 21 to cover many basic rights under it, so that giving them the status of fundamental rights, they can be enforced against the state also, even by a public interest litigation. So another factor which contributed to the judicial activism was the expansive judicial interpretation placed on the expansion life in the same article. So that is the difference between the judicial review and judicial activism. So this is the judicial review and judicial activism position in India. So as we discussed, in case any law declared by the Supreme Court becomes binding all our courts, that's what we called it as Supreme Court. So the Supreme Court proceedings and orders are guidelines to the entire courts in India. So the primary function of these courts is to give justice to the people. So the first and foremost function of the judiciary is to give justice to the people whenever they may approach it. So it awards punishment to those who, after trial, are found guilty of violating the laws of the state or the rights of the people. So meaning, the nature, the scope of past. So the interpretation of laws by the judicial amounts to lawmaking as it is there. These interpretations which really define the laws. So moreover, the judgments delivered by the judicial courts are higher courts, which are the courts of record, are binding upon lower courts. So the latter can decide the cases before them and the basis of the decisions made by the higher courts. So here the judicial decisions constitute a source of law. So, and also it is acts as protection of rights as we discussed. So this is the structure, functions, powers of the Supreme Court and the special powers of the Supreme Court. And we have discussed about judicial review and judicial activism. So is there any doubts regarding today's lesson?
I have.
Sir, what is the actual meaning of judiciary meaning?
What? Come again.
So she asked the actual meaning of judiciary.
Advisory.
No, sir, the actual meaning of judiciary that she asked.
Judiciary meaning. So judiciary.
Yes. Actual meaning of it.
Actual meaning of judiciary. So judiciary meaning is it is a third organ of our government. So there is various levels of judiciary there. Different types are there. So in that only we are discussing about the Supreme Court and the High Court and subordinate courts. So the real meaning of law is judiciary.
Who's not involved in judicial functions? Who's not involved in judicial functions?
No one is involved. So that's what we call it as independent judiciary. That's what the judiciary is became independent, because executive or legislature cannot enter into the actions of the judiciary.
So we can say that judiciary is a law, right?
Yes, yes.
Sir, you told about breaths, right? Like can NRA avail the facility of breath?
What?
You told about breaths, right? So can NRA people or OCI people can avail the facility of breath?
Reads. Yes. Some cases, in case of Article 14 is there for all. In some cases, some exemptions are there for NRIs or foreigners. Otherwise, all are equal before the law, according to the Article 14.
Sir, then writs are issued only by Supreme Court or even like some high courts also?
Writs,
only Supreme Court can issue? Yes, sir.
No. Supreme Court and High Court, both are having the power to issue writs. According to Article 32, Supreme Court is having issue writs, 5 types of writs there. According to Article 228, High Courts also has the power to issue writs. Same like 5 writs. So in states, the rights issuing authority is given to the High Courts. At the union level, Supreme Court.
So then that same 5 writs for even like in the High Court level, I mean like in a union level and even in the state level?
Same state
Same
level also
writs.
5. Habeas corpus, mandamus, certiorari. prohibition and power.
So,
Sir,
state
then
and union both will have the same authority, sir.
Yes, yes.
Okay.
Supreme Court is the highest because Supreme Court
No, no,
cannot.
I'm not asking about courts. I'm asking about like union and state is there, na? So what state can do that union can do?
Yes. Both are having same powers.
Okay.
So high courts are assisting the Supreme Courts. So Supreme Court cannot resolve all the states issues. That's what Supreme Court is having subordinate courts like high courts for every state. And also high courts are having subordinate courts like district courts and other class 1 courts or criminal civil courts also there to assist them. But here the highest authority to give or issue writs is given to the only higher courts like Supreme Court and High Courts only, not to the subordinate courts.
High Court and Supreme Court will have same authority, or anyone is bigger than each other?
At this context, the Supreme Court is the highest power. So
as compared to High Court.
Yes, highest power than High Court.
Okay.
High Court is the high court in state. So Supreme Court is highest court in the entire nation.
Entire nation?
Yes, India.
Okay.
what's the difference between district court and sessions court?
Difference between?
District court and sessions court.
District courts and session courts are subordinate courts to the High Court. The power distribution is different from these.
Every district will have High Court?
No. They will have only district courts.
Okay.
High Court is only for the state, entire state. Like Telangana is having one High Court. Andhra Pradesh is having one High Court. Tamil Nadu also having one High Court. Like that.
And what is the difference between PIL and SAL?
PIL is a public interest litigation.
Then SAL also is the same, right? Like social action litigation.
Yes.
So what's the difference between those both?
Between?
So then what is the difference? Like this both are like same of the same context, right? But why do they both have like different things?
PIL and other one is?
SAL, sir.
SAL.
Social action litigation.
Both are different. So PIL we can approach the High Court and Supreme Court. Okay. Okay, thank you for your participation. I am concluding the session. Thank you.
Sir.
Thank you, sir.
Okay, thank you. Yes.
Just now you showed the slides, now, sir. Can you please share that once?
Okay, sure. I will.
From first to end.
So here I will drop my number. You can text there. I will drop PDFs and PPTs regarding our syllabus.
Okay, sir. Thank you.
I dropped my number. Save that number. Just to text me. Text or WhatsApp. Anything. Okay, thank you.